why the Trump trial should concern all Americans. Now, over the last few days, we've had people reach out, people listen to the pod and said they were looking forward to us covering this. And to be fair, me personally, I know you just because you're busy running, building businesses, like the amount of depth of time to go into the last, 6 weeks of trials and everything else, we haven't had that. But when you think about the verdict, there's multiple different ways people can feel about it. And so thinking about you listeners out there, I titled it Why the Trump trial should matter to all Americans is because regardless of whether you know the details and where you stand on it, there's clearly some things that took place to make this trial come about that when under not even a magnifying glass or just a clear glass, you could see, well, that's kind of whack. And so rather than get on the podcast and pontificate about that, I found an article from Ali Honig, who writes for the New York Magazine. Now, he's regular. Now, if you think just because we're conservatives, this is going to be a Fox News guy. Well, this guy actually is on CNN quite a bit. He's in left and Democrat circles, and he's willing to be on the right side of things too. But he was a former prosecutor, knows a lot, much like Justin, our guy. And he wrote this article that I think no matter where you land politically, this should challenge you to try to view what happened through an objective lens. And so if Cole can scroll down, you can find this on New York Mag. He says, the following are all undeniable facts. Now, this is someone who has followed this case, the entirety, is in this world, speaks the language, understands the law, operated in New York with some of the people involved in the case. And he said, the following are all undeniable facts. The judge donated money, a tiny amount, $35, but in plain violation of a rule prohibiting New York judges from making political donations of any kind to a pro-Biden, anti-Trump political operation, including funds that the judge earmarked for resisting the Republican Party and Donald Trump's radical right-wing legacy. Will folks have been just fine with the judge staying on the case if he had donated a couple bucks to re-elect Donald Trump MAGA forever? Absolutely not. He continues on. District Attorney Alvin Bragg ran for office in an overwhelmingly Democratic county by touting his Trump-hunting prowess. He bizarrely and falsely boasted on a campaign trail, "It is a fact that I have sued Trump over 100 times." Full disclosure, both Bragg and Trump's lead counsel are friends and former colleagues of the author. Most importantly, the DA charges against Trump push the outer boundaries of the law and due process. That's not on the jury. That's on the prosecutors who chose to bring the case and the judge who let it play out as it did. The district attorney's press office and its flax often proclaim that falsification of business record charges are commonplace, and indeed the office's bread and butter. That's true only if you draw the definitional line so broad as to render them meaningless. Of course, the DA charges falsification quite frequently. Virtually any fraud case involves some sort of fake documentation. But when you impose meaningful search parameters, the truth emerges. The charges against Trump are obscure and nearly entirely unprecedented. And remind you, who is that coming from? It's not coming from Samson and I. In fact, no state prosecutor in New York, Wyoming, or anywhere has ever charged federal election laws as a direct or predicate state crime against anyone for anything. None ever. Even putting aside the specifics of the election law, the Manhattan DA itself almost never brings any case in which falsification of business records is the only charge. So what we're seeing is this is a novel sequence of operation. And the question is, why? Why is that? Not only is it novel and questions why, it's also outside of the bounds of their normal way of doing it and what the law actually has allowed them to create as precedent of operating. So very interesting. Standing alone, falsification charges would have been mere misdemeanors under New York law, which poses two problems for the DA. First, nobody cares about a misdemeanor, and it would be a laughable thing to bring the first ever charge against a former president for a trifling offense that falls within the same technical criminal classification as shoplifting a Snapple and a bag of Cheetos from a bodega. Secondly, the statute of limitations on a misdemeanor, 2 years, likely has long expired on Trump's conduct, which dates back to 2016, 2017. So normally this is a misdemeanor, and normally the statute of limitations wouldn't even be bringing this to the forefront. So why is it happening? Why did it happen, rather? So to inflate the charges up to the lowest level felony, Class E, on a scale from A to E, and to electroshock them back to life within the longer felony statute of limitations, the DA allegedly alleged that the falsification of business records was committed with intent to commit another crime. Here, according to prosecutors, the another crime is a New York State election law violation, which in turn incorporates 3 separate unlawful means: federal campaign crimes, tax crimes, and falsification of still more documents. Inexcusably, the DA refused to specify what those unlawful means actually were, and the judge declined to force them to pony up until right before closing arguments. So much for the constitutional obligation to provide notice to the defendant of the accusations against him in advance of trial. This, folks, is what indictments are for. In the key respects, the charges against Trump aren't just unusual; they're bespoke, seemingly crafted individual for the former president and nobody else. I will say, just in the interest of time, I'm going to save some of these paragraphs. He's almost over, but look at what he said. In the key respects, the charges against Trump aren't just unusual; they're bespoke. Guys, if you don't know what bespoke means, think custom, think brand new, came out of nowhere with something that's fresh, seemingly crafted individually for the former president and nobody else.
Yeah, so basically he's saying there's no precedent.
No precedent at all.
It's never been done before.
No precedent at all. And so
the precedent would actually imply the exact opposite.
Correct. And so when we're thinking about people who are celebrating this, justice has been served, no man above the law, you should be very concerned that you're celebrating this because you're not understanding what's actually happening.
Well, as we experienced when Justin came on, so my friend Justin North, who works for Gessler Blue, was on the Trump case when they were trying to remove Trump from the ballot in Colorado, amongst a few other states, and their team saw it all the way up to the Supreme Court, where it was ultimately killed.
Right.
And at the Supreme Court, where you have 3 Democratic Supreme Court justices who all ruled against it and overturned the ruling at the state level, basically said that, hey, if this actually stands, we're going to set a precedent that will ultimately be used against us.
Correct.
And in that particular case, in states where it's not one way or the other, effectively, you would have basically the candidates could be removed both from the Democratic Party and the Republican Party, which effectively would destroy the republic and ultimately destroy the whole entire, constitutional republic that we've set up in the voting structure that we've set up. And so I think that what's ultimately going to happen is a similar thing. It's just a dog and pony show, an attempt to blaspheme the name of Trump, and further try to limit his ability to run for president.
Correct.
This year.